Mr. Schroeder, thank you very much for being here. I think we've reached the logical conclusion of our conversation at this point. Our process is that Senator Kennedy and I are going to review a report that the subcommittee could prepare and propose to the full committee. When we have bipartisan agreement on that, I'm sure we'll share it with you so that you can offer whatever comment you wish. The intention of it is not just to be a report that goes to a shelf to gather dust with other reports in the dust-gathering shelves of Congress, but to be a basis for formulating legislation that creates a process upon which both parties can rely that is much more efficient, that leads to quicker accommodations. And I think I've said it before, so I don't think I'm giving away any secrets when I say it here, but as somebody who practiced law for a bit, I always found that conferences with the court before a trial or before a motion hearing could be very instructive, and magistrates handling those conferences could be very instructive. A lawyer who was asked by a magistrate, "You don't seriously intend to bring up that argument before the judge, do you?" Or, "If you try to raise that as a factual assertion, I'm afraid you're going to have heavy sledding because it does not appear to be supported by the evidence." Those sorts of things can help sharpen the mind quite a lot and narrow the arguments and provoke settlements. And I think something like that, where we have a chance to have some entity perform that role at some point, is the direction that I'm looking for. I found those experiences very fruitful in terms of preparing for trial and motion practice in courtrooms. People talk big, and they've got their own theory of the case. But as they say, everybody's got their theory of the fight until they get punched in the face. And then suddenly you have to figure out in real life how you solve this problem. So thank you for being here. Thank you for your work at the Department of Justice. And if anybody has further information they'd like to provide to the hearing, the record will remain open for a week. And I wish you well, and I hope that it's less than 20 years before an assistant attorney general in your position appears before this committee for something other than a nominations hearing.
Well, thank you for your courtesy, Mr. Chairman. I know we haven't seen eye to eye on everything, but I think we agree that this is an important topic. If there are improvements to be made, the department will review anything that in the legislative arena that you want to propose and provide you our considered views that you can take into account going forward. And if we can continue the conversation in any way, I would be happy to do that with you.
Good. Well, we look forward to that. The conversation will continue. And the one question for the record, I think, that is outstanding out there that I'd like to have an answer for in the time frame of responsiveness to this hearing is the question of whether there are any guardrails that could give us more assurance that one administration's view of this is not readily and immediately supplantable by another administration, that for a whole variety of reasons, which could include that the congressional oversight is looking at administration malfeasance, simply does not want to abide by. If it's just jump ball every time, then we're in a very different world than if there's some real guardrails around DOJ or around OLC. So with that, the hearing is adjourned, and I thank you again, sir.